Welcome back to LAGD. We're finishing up our discussion on trademarks. In the first part of this episode, we talked about what trademarks are and what to consider when naming your game and your company. In part 2, we talked about the benefits of formal trademark registration, how much it costs, and whether you could do it yourself. This last part wraps up with question 4 and some conclusion stuff. Question 4. How can you enforce your trademark rights even if you can't pay for a lawyer? First things first. Say you make a game and all of a sudden, you have fans! Woo! You did it! I'm so proud of you. Aren't you proud? I'm proud. Okay. Now these fans are making fan websites and fan films and fan Etsy shops, and they're making doilies shaped like your character. Even though these people are technically infringing on your trademark, they're definitely not the type of people you would have a problem with. After all, they're your fans. What you may have a problem with, though, are companies that mass-produce merchandise without your permission, or websites that pretend you're you and ask for donations. These people are clearly not fans. They're also probably making crappy, cheap products for your fans to buy, or they're completely swindling your fans by asking for donations in your name. You want to obliterate these guys? Who are you gonna call? Ghost! No, new media rights! Yeah! That's right, you can enforce your rights even without having a formal registration. And you don't necessarily need a lawyer that you have to pay for unless things get really complicated. Here are 2 steps that you can take to stop these freeloaders in their tracks. Step 1, get a gun. Wait, no. If you do identify someone doing something unscrupulous with your trademarks, you can send a cease and desist letter. This can mean a lot of things, but in practice, this means that you send them a letter that tells them A, you're the trademark holder, B, talk all about the trademark rights that you have that you get automatically, and C, ask them to stop doing what they're doing. First, you should send your email letter directly to the person who's causing the problems. If that doesn't work, you can send it to the site's web host. If that doesn't work and it's a Facebook page or a Twitter account, you can send your notice directly to one of those intermediary companies. If that doesn't work and the website has advertisers, you can alert all of the company's advertisers. Finally, if that doesn't work and the company uses a payment processing thing like PayPal, you can tell their credit card processors that they're working for a no-good freeloader who's doing something illegal. Typically, even when the individual is a bad dude who ignores your letters, the site that's hosting the infringement, like Zazzle or Etsy, is likely to be open to working with you to fix the problem. The point is, you shouldn't just give up if the person doesn't give in to your reasonable demands. Any good lawyer would keep contacting all of these other people until the problem was solved. So should you. Get creative, but stay legal. Step 2. Assuming that your letters didn't work and you can't afford a private attorney, you can contact an organization like California Lawyers for the Arts or New Media Rights. Depending on your circumstances, we could potentially help you rewrite and send your letter, or we could pull some other strings that only the threat of a lawsuit can pull with these people. Step 3. You can file a lawsuit or other type of more formal legal action. You can request an injunction with the court. This would stop other people from using your trademark. Or you could use all sorts of other legal processes, but everything in Step 3 costs a lot of money, and to be frank, they're outside the grasp of most small developers. Assuming that there's a lot of money at stake, it could be worth talking to New Media Rights to discuss strategy or shopping around for a lawyer that could take your case. Moving on, there's one last thing that I think is worth talking about before class is dismissed. You may have one lingering worry with regards to protecting your game. Clones! Scary! Neither copyright nor trademark law does much to prevent others from making very similar games with very similar names. So long as there's no confusion for the consumer as to who is the source of the game, the law has no problems with clones existing. This is sometimes great for small developers, but also sometimes terrible when large companies clone other small companies' innovative concepts. We'll talk more about clones in another video that's more relevant to the subject. In conclusion, come up with a creative, fanciful name for your game. Don't be generic. You don't have to register your trademark to be able to enforce your rights, but formal registration does have its perks. And if you finally do end up going the registration route, consider talking to a lawyer about it rather than trying to do it yourself. Stay tuned for some more interviews with indie game devs on managing their mark in the trade. Check out the other LAGD episode playlist, and don't forget to subscribe to the New Media Rights YouTube channel. If you like the information we have to offer, and you want others to have one-on-one help with trademark issues, donate at our YouTube channel or at newmediarights.org. I'm Lauren with LAGD. Thanks for watching.